It's early morning in Washington, January 2026. Before most Americans wake up, something extraordinary is already unfolding behind closed doors across the federal court system. From district courts in California to appellate panels in New York, from the Supreme Court itself to clerks' offices overwhelmed with filings, the legal machinery of the United States is under unprecedented strain. Lawyers are filing emergency briefs at a record pace. Judges are issuing late-night orders. Constitutional scholars are working through the night, confronting legal questions that have not been seriously tested in generations. The numbers alone tell a story that should give anyone pause. As of early January 2026, more than 583 lawsuits have been filed challenging actions taken by the Trump administration. Not over 4 years, not over an entire term, in just 12 months. To put that in perspective, during all 8 years of the Obama administration, roughly 160 lawsuits challenged executive actions. During Trump's entire first term, about 300 cases were filed. This time, that number has nearly doubled in a single year. But this moment is not just about volume. It's about what these cases represent. These are not routine policy disputes dressed up as legal arguments. They are fundamental challenges to the limits of presidential power itself. Challenges to whether a president can push past boundaries that have constrained executive authority since the founding of the Republic. And at the center of this storm sits the Supreme Court, an institution known for moving slowly, deliberately, carefully, is now facing multiple urgent questions at the same time, questions that will shape the presidency for generations, long after Donald Trump leaves office. Right now, the court is preparing to rule on 3 cases that legal scholars describe as the most serious tests of presidential authority since Watergate. Let's walk through them because the details matter. First, birthright citizenship. On January 20th, 2025, Trump's first day back in office, he signed an executive order attempting to end automatic citizenship for children born in the United States to parents who are undocumented or in the country temporarily. This strikes at the heart of the 14th Amendment. Ratified in 1868 after the Civil War, it states clearly, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States." For more than 150 years, this has been understood to grant citizenship to nearly everyone born on American soil, with only narrow exceptions, like children of foreign diplomats. Trump's order argues that children of undocumented immigrants are not subject to the jurisdiction of the United States and therefore are not citizens. Legal experts across the ideological spectrum have called this interpretation unprecedented and unconstitutional. In 1898, the Supreme Court directly addressed this issue in United States v. Wong Kim Ark, ruling that a child born in San Francisco to Chinese immigrant parents was a U.S. citizen even though his parents were barred from citizenship themselves. Here's what makes this case extraordinary. Every single federal judge who has reviewed Trump's order has ruled against it. Courts in New Hampshire, Maryland, Washington, and California all blocked the policy. The Ninth Circuit Court of Appeals ruled that it violates the plain text of the Constitution. And yet, the Supreme Court agreed to hear the case. Oral arguments are scheduled for early 2026, with a decision expected by June, just months before the midterm elections. The court could have shut this down immediately. It didn't. Some court watchers believe the delay is strategic, meant to weaken Trump politically before delivering a defeat. Others worry it signals something far more serious, that parts of the court may be open to rewriting constitutional law that has stood for more than a century. Next, tariffs. This case may be even more consequential. Trump declared a national emergency and imposed sweeping tariffs on imports from dozens of countries using a 1977 law known as the International Emergency Economic Powers Act. That law was designed for real emergencies: terrorism, war, national security crises. Trump is using it to reshape global trade policy. The constitutional question is simple and explosive. Does the president have the authority to impose massive tariffs without Congress? The Constitution gives Congress, not the president, the power to regulate foreign commerce and impose duties and taxes. During oral arguments in late 2025, even conservative justices expressed skepticism. Questions from Justices Barrett and Kavanaugh focused on whether there are real limits on presidential authority under this emergency law. If the court rules against Trump, the government could be forced to refund billions of dollars in collected tariffs, collapsing his signature economic policy overnight. If the court rules in his favor, it would permanently shift power away from Congress, giving future presidents unilateral control over trade policy. A decision could come at any moment. Then there is the Federal Reserve case. Trump attempted to fire Federal Reserve Governor Lisa Cook, citing policy disagreements. Federal law allows Fed governors to be removed only for cause, not for political disagreement. The entire structure of the Federal Reserve exists to protect monetary policy from political pressure. Trump's argument is radical. He claims that all executive branch officials, including those at independent agencies, serve entirely at the president's pleasure. If the Supreme Court accepts this argument, it would overturn nearly 90 years of precedent. A president could fire Fed officials who refuse to cut interest rates before an election, fire regulators who investigate political allies, fire watchdogs who refuse to look the other way. Independent regulation, as Americans have known it, would effectively end. These cases are not isolated. They are part of a broader pattern that legal scholars increasingly describe as a constitutional stress test. In multiple instances throughout 2025, courts ordered the administration to stop certain actions. Instead of complying or appealing in good faith, the administration engaged in what experts call legalistic non-compliance, technical arguments designed to avoid obeying court orders without openly defying them. In one case, a man mistakenly deported to El Salvador remained there despite orders from multiple courts, including the Supreme Court, directing the administration to facilitate his return. In another, deportation flights continued despite an emergency judicial order stopping them. Judges in multiple jurisdictions have openly stated that their orders were defied. Chief Justice John Roberts, who rarely speaks publicly, warned in a 2025 speech about threats to judicial independence, including efforts to defy lawful court judgments. That was not abstract, it was a warning. Historically, when presidents crossed constitutional lines, Congress intervened. During Watergate, Republicans ultimately told Nixon his presidency was over. Today, Congress remains largely silent. That leaves the courts with limited enforcement tools, all of which depend at least partially on executive cooperation. This is the question at the center of this moment. What happens if a president decides court orders are optional? This isn't about Donald Trump alone, it's about the precedent being set for every future president. If courts cannot enforce their rulings, executive power becomes limited only by political will, not law. The next few months will answer questions Americans never expected to revisit. Will the Supreme Court draw firm lines around presidential authority? Will Congress reassert its constitutional role? Or will precedents be set that permanently concentrate power in the presidency? History will look back at 2025 and 2026 as a turning point. Either the system held or it didn't. If you value clear analysis over sound bites, stay with us. We'll break down the rulings as they come, explain what they actually mean, and track what holds and what breaks. Because this story isn't about politics. It's about whether the rule of law still works. And that affects everyone.